Well, good afternoon, everyone, and welcome to the American College of Bankruptcy 7th Circuit Education Committee's 11th Annual Bankruptcy Seminar. I want to give a special welcome to folks that are joining us from outside the 7th Circuit today through the magic of Zoom. The mission of our committee is to promote knowledge of bankruptcy law through programs like this. And I'm confident that after you listen to the wonderful program that we have planned for you, that you're going to agree with me that we have more than fulfilled our mission. I want to give a number of thank yous. First, to the members of my committee that have been working since February to put together this program. Thank you also to the panel moderators and the panelists. The panelists have put in countless hours preparing materials, which you can find either through a link in the invitation that you received or in the college's website. The moderators and the panelists have worked together to present what I'm sure is going to be an informative and entertaining program with a minimum of folks just reading from PowerPoint presentations. I also want to thank Sherry Bedker, the Executive Director of the American College of Bankruptcy. This is our first Zoom webinar, and without her technical expertise, this simply wouldn't be possible. Also, thanks to Jennifer Cudahy, who did a fabulous effort making sure that people from all of the states that are participating in this will be getting CLE credit for the program. Last but not least, I want to thank Cynthia Nowacki, Perkins Coie's Director of Marketing. Cynthia has worked tirelessly to put together the programs and invitations that you've seen with all folks and to keep track of registration requests. And without her, this whole program would not work as smoothly as I'm confident that it's going to run. Some housekeeping matters. You will be receiving CLE credit for the program. 2 CLE codes will be flashed during each panel presentation through the chat function of Zoom. Be sure and write down those codes, because after the program, you'll be receiving an email from the college asking you to report those codes. The college will then forward the codes on to the various state agencies that issue the CLE credits. We do have the opportunity for people to ask questions. You'll see that through the Q&A button at the bottom of your screen. Please write your questions, and using that function, Sherry Bedker is going to collect the questions and forward them on to panel moderators, who will pass them along to the panelists if we have time to answer all the questions, and if not, the panelists will try their best after the program to send out answers to the questions. There are 2 breakout sessions today. One is on consumer law and the other is on healthcare law. You'll see the instructions for joining those sessions in your email that you got with the links. So be sure and take advantage of the breakout sessions, which we are doing today for the first time. Finally, I want to make a pitch for the Bankruptcy Help Desk in the 7th Circuit to those people who are in Chicago. The Help Desk is run by the Legal Aid Chicago. Dan and I have worked on it, and I think some other people have as well. One day a week, we volunteer now virtually to help pro bono clients fill out their petition, schedule, statement of affairs, and prepare motions for relief that they may need in court. It's a very gratifying way of fulfilling your pro bono responsibilities. The clients are very grateful. The bankruptcy judges are grateful that pro bono clients don't hold up the the court sessions the way they do if they're properly advised by the folks that volunteer. So the other advantage, of course, is that if you are a member of the trial bar, being a volunteer at the help desk relieves you of your responsibility for representing pro bono clients in district court matters for which you probably, at least I never did, have any familiarity. So you can use your bankruptcy expertise to fulfill that requirement. And with that, I am going to turn it over to Vince Lazar of Jenner and Block. Vince is the Seventh Circuit representative for the college's foundation, and he's going to tell you about the wonderful work that the foundation does. So Vince, the screen is all yours.
Great, thanks, Rick. As Rick mentioned, I serve on the board of directors of the American College of Bankruptcy Foundation. That is the charitable arm of the college. Every year around this time, the foundation seeks contributions to support its mission, which is to provide financial aid to organizations that in turn supply bankruptcy and insolvency related services to the indigent and underserved populations. The foundation is the largest single source of financial aid in the country to organizations that supply these types of services. The foundation's work is all done for free. 100% of all donations directly go in turn to support the legal aid and other organizations that are getting our support. The organizations that get financial support are vetted by more than 40 volunteer judges, lawyers, and financial professionals on the college's pro bono committee. Those organizations include national organizations and local organizations in the Seventh Circuit, like the Illinois Legal Aid Online, Indiana Legal Services, and District 10 Pro Bono Project in Bloomington, Indiana. As I think all of you know, this has been an incredibly difficult year for charitable organizations, which have seen their sources of both private and state funding dry up as a result of the pandemic. And I also know that most of you already support a number of very worthwhile charitable organizations in your own communities. However, a donation to the foundation, which in turn is directly supports other organizations that provide bankruptcy services, is one of the few opportunities you will have to make a charitable donation to a cause that is directly tied to our profession and is a great means of giving back to the bankruptcy and insolvency community that permits us to be here today. Easiest way to make a donation to the foundation is by clicking on the link that you can find on the college's website, which is www.americancollegeofbankruptcy.com. American College of Bankruptcy, one long word. If you want to make a donation by check, there's a form and instructions for doing that on the website as well. Or you could just contact me by email and I'll be happy to help you. Thank you for your time and generosity. And with that, I'd like to turn it over to Jamie Sprayregan, college's regent for the Seventh Circuit.
Good afternoon, everybody. I'm pleased to talk to you for just a couple of minutes before we start the formal program. Thank you, Rick, for all you did in organizing the program, and thank you, Vince, for the efforts on behalf of the foundation. I just want to remind everybody on this seminar are already fellows of the college, but as you know, the college is an honorary public service association of folks from the U.S. and actually around the world, of professionals who have a proven record of in their professional area, but also in terms of giving back to the community, in terms of teaching and charitable and pro bono activities. We are in the midst of going through the process of admitting new fellows for this year over the next few months. But if people have prospects for the next cycle after that, we're always all ears and like to hear about new candidates. We have a particular commitment to education. We have a commitment to diversity. We have a commitment to pro bono work, which Vince has just discussed through our sister foundation. And we actually maintain the National Bankruptcy Archives too. And we do a lot of these educational programs across the country. We publish scholarly articles. And we're dedicated to enhancing professionalism, scholarship, diversity, and service to the bankruptcy and insolvency community, including professionals, judges, academia, legislators, etc. So thank you all for your service to the college and for joining us today. And with that, I'd like to turn it over to the first panel, which is to be introduced by Professor Ralph Brubaker from the University of Illinois College of Law, my alma mater. So Professor Brubaker, please take it away.
Thanks very much, Jamie, and welcome everyone. The first panel is going to discuss recent developments affecting practice in the Seventh Circuit and to some extent beyond the Seventh Circuit. I am, as Jamie said, Ralph Brubaker. I'm a professor at the University of Illinois. My fellow panelists are Douglas Baird, who's the Harry A. Bigelow Distinguished Service Professor at the University of Chicago Law School. Doug, if you could wave to everybody. Bruce Markell, who was formerly a bankruptcy judge, who's now a professor of bankruptcy law and practice at Northwestern University Pritzker School of Law. Bruce, if you could give a wave to everybody. And last but not least, Rick Mason, who is a founding and name partner of Mason, Pollick, and Schmahl in Chicago. And we've got Rick, go ahead and give a wave to everybody if you can. And we have several interesting developments we want to discuss, and we'll just dive right in. We're going to start with some developments regarding fraudulent conveyance law, and Douglas is going to lead the discussion here. So Douglas, take it away.
Well, thank you. I think the first thing I want to flag for people is the Uniform Avoidable Transactions Act, which is the law now in Indiana. It's been introduced in Wisconsin. It's now also the law in California and perhaps more significantly in New York. And it essentially replaces the Uniform Fraudulent Transfer Act and is matters over two dimensions, one obvious, one perhaps not so obvious. The first is the basic substantive change it had, which deals with conflict of laws. It now actually has a clear conflict of laws provision. The law that applies is the law of the debtor's residence. And that matters in international transactions. It probably also matters, perhaps most significantly, with respect to debtors who engage in asset protection trusts and the like. And that may actually be one of the engines that is perhaps holding up this statute from being more widely embraced. Bruce, am I right in that intuition that's one of the stress points here?
Yeah, the asset protection bar has got a bee under their bonnet about some of the changes actually to the comments, because the Avoidable Transactions Act is basically just morphing the Uniform Fraudulent Transfer Act. And they're concerned that their efforts to protect the assets of people who have assets to protect might be undermined by this law. And they have, in Michigan, they opposed it, and they will show up at legislative hearings. And so I think it's probably the fact that it got through New York is kind of an interesting point. But I think you're spot on. There is one group who, for whatever reason, doesn't like this, and they're all to at least slow it down.
Well, in terms of the other big substantive change, one of the things they've done is they've basically dropped the use of the F word throughout. So except for actual intent to hinder, delay, or defraud, there's no use of the word fraud in the comments or elsewhere in the text. Now, this doesn't actually make a difference, since we all know that actual fraud is not a necessary element for a fraudulent transfer to have taken place, as long as there's a badge of fraud, such as insolvency, transfer to an insider, transfer done in secret, transfer done for no economic purpose. As long as there are enough of these indicia, you never get to the issue of fraud. But it does really underscore, and it may make judges more aware of the idea that you don't need to look for actual fraud, and the net of fraudulent conveyance law, I think, is much wider than people typically see. For example, I think there's some courts that actually require you to plead fraud with specificity when you have an actual intent fraudulent conveyance. Not clear why that makes any sense. Not clear that will make any sense at all in a statute that doesn't even use the word fraud. So that's one big change you should flag for the fraudulent conveyance area. Another area I don't want to spend a lot of time on, but because there is a hugely salient Seventh Circuit case that may not be good law anymore, it's worth flagging. 546E limits the ability to bring fraudulent conveyance actions when there is a leveraged buyout, or at least seems to on its face, because it says if there's a settlement payment, then that's going to be exempt from the trustee's ability to bring an ordinary constructive fraudulent conveyance action. We all know that in the Seventh Circuit, we had a case called Merit Management that said if the financial institution is between, in other words, if you have the debtor, then a financial institution, then an ultimate recipient, and the financial institution is just counting as a conduit, then that doesn't count for purposes of 546E. So it might seem that if you read that case in the Seventh Circuit, it might seem that you don't have an impediment under 546E. But in fact, you may, because of a recent Second Circuit opinion that's now on cert, in which they said, no, wait a second, hang on. What is forbidden by 546E is a constructive fraudulent conveyance action, even given merit management, if it's from a financial institution to somebody. As long as there's a settlement payment from a financial institution to someone, it counts as a fraudulent conveyance. Well, guess what? Financial institution is a defined term. And if you look at the definition, when a bank is acting as an agent of a customer, the customer is defined as being a financial institution. And so if you read the statute literally, if you have someone who has a bank making a settlement payment and is acting as the person's agent in the course of a leveraged buyout, that is a transaction that's picked up by 546E. It doesn't make any sense as a matter of first principle, but this really was the legislative intent, in the sense that the people drafting the law wanted to cast a broad net because they're worried not about this transaction, but about other transactions. And so this is a case that you just want to follow. And again, it's now on cert. Two other quick issues. There has been a certain amount of litigation outside the Seventh Circuit about the extraterritorial reach of the avoiding powers as a general matter. And again, we saw this in the Madoff Ponzi scheme, where you have a transfer from a debtor in New York to an offshore entity, and then that offshore entity makes another transfer to someone in Europe, let's say. And the question that some courts have asked is, gee, can the trustee reach that other person in Europe, even though there's a transfer from the debtor in New York assets to an offshore entity, and then by the offshore entity to someone in Europe? Well, how do we think about that? Without going through what various courts have said, the right way to think about that is to ignore the transfer between the offshore entity and the person in Europe. The right question is, wait a second, we have the avoidance action. The avoidance action belongs to the debtor. It's property of the estate under 541. Because it's property of the estate under 541, the trustee has the action. It is explicitly worldwide. And at any rate, if you want to find a locus for the avoidance action, it's going to be where the debtor is located. There's no doubt that the trustee has the power to bring that action. Now, whether the trustee can bring it successfully, whether the judge will be recognized in another jurisdiction, that's anyone's guess. But the actual fact that the avoidance action is property of the estate is relatively straightforward. Unfortunately, there's a little bit of hand waving you have to do here because of the way 541A is written, because it's the debtor's property at the time of the petition, and then it's stuff that's acquired after the petition under 541A7. And there isn't explicit language about stuff that comes into being at the time of the petition. But that seems a fine point. And I think we all usually assume that avoidance actions are in fact property of the estate. And then the last point of interest that's worth flagging is a question of how we think about proceeds when it comes to avoidance actions. And the reason to raise this is there was a recent case from the 10th Circuit that is, at least from a law professor's point of view, really not quite right. So let me, in classic
No,
law
it's absolutely wrong.
It's Well,
I mean,
again,
I'll go out on a limb. It's
yeah, you can go
absolutely
out-
wrong.
No, I think it's absolutely wrong too, but I don't want to, but if you practice in the 10th Circuit, you actually have to live with it. But here's the hypothetical that that this opinion triggers, and at least in Professor Markell's view, gets wrong. I have a friend who comes to me and says, Douglas, I'm being hounded by my creditors everywhere, and I want to hinder, delay, and defraud them. Will you take this book from me as a gift? And I say, sure, absolutely. At this point, I go to Bruce and I say to Bruce, I have this book that was given to me by a friend who was trying to hinder, delay, and defraud his creditors. Would you like to have this book in exchange for your painting? And Bruce says, sure, and we make the trade. At this point, my mother's birthday is coming up, and I give the painting to my mother. Okay. The creditors of my friend now are exceedingly unhappy, and what they want to do is they want to go after everyone they possibly can. And the question is, who can they go after? And the short answer to this question is they can go after everybody. They can go after me because I've received a fraudulent conveyance, and I don't have a good faith defense. Bruce, in receiving the book, can also be subject to a fraudulent conveyance attack because he doesn't have a good faith defense under 550. He doesn't have a good faith defense under 550 because I told him that I got this as a result of a fraudulent conveyance. What about my mother? Well, my mother, of course, didn't give any value for the painting, but you say, well, wait a second, the painting wasn't fraudulently transferred. But the issue here is, how do we think about proceeds? The reality, this is just like security interests under Article 9. When I got the painting back from Bruce as proceeds of the fraudulent conveyance, my creditors can reach not only the book in Bruce's hands, but also the painting in my hands. And if I convey the book to my mother and she's not a BFP, then my creditor's ability to reach the painting in my hands will also mean they can reach it in my mother's hands because she doesn't get the protection of 550 either. And again, this is the way you need to think about proceeds and the reach of fraudulent conveyance law with respect to proceeds. That is the result under non-bankruptcy law. No reason that we should read 550 to reach a different result there either.
Except that the 10th Circuit did, right?
No, law professors don't have to worry about stuff like this. I think the problem with the 10th Circuit is they just got lost in abstraction. It's a very complicated case, and there's intangible assets and litigation that goes on for a long period of time. A lot of dust that's thrown up in the air. There's some ambiguity about whether or not they're good faith defenses. Everything gets relatively confused, and it's not very clearly argued. It's not sort of reduced to this idea of tangible assets being passed back and forth. And I'm pretty sure that if someone had said, wait a second, think about this as you would a proceeds problem under Article 9, where we all know that if you have a security interest in my book and I sell the book and I get money, the security interest continues not only in the book if it's sold outside the ordinary course, it also consists in any identifiable proceeds. That's not something peculiar to Article 9. It's a standard common law rule. We see it in the restatement of restitution. Again, I don't think this area is that complicated once you think about it. But if you don't think about it, as the 10th Circuit appears not to have, you can get misled. Another way to think about it without being disrespectful to the 10th Circuit is that if you're not practicing in the 10th Circuit and you come across the issue of proceeds and 550 and how it plays itself out, you should use this 10th Circuit case with an exceedingly large amount of caution. It's a case that might look okay, and it might look like it's doctrinally reasonable, but if you press very hard at all, it really isn't.
But isn't the other lesson that the 10th Circuit case could really bite you, because the court uses what's a facially plausible means of reaching its decision, which is very popular in the federal courts, was just strict textualism. And they said, 550 doesn't say anything about proceeds. And it goes back to this 541 argument that, right, well, there's a proceeds thing in 541, but it doesn't talk about proceeds of a fraudulent conveyance action or any other kind of avoidance action, and sort of exploits this ambiguity in 541, whether an avoidance action is property of the estate under 541 or not. So you could argue it was doing exactly what the Supreme Court has told the federal courts to do, which is start first with the language of the statute. If the language of the statute is clear, that's the end of the inquiry. How do you deal with that? Because people are going to start arguing this 10th Circuit case, I assume, all over the place.
Well, I think you have to, no, obviously we have a statute, but there are words in the statute you still have to figure out the meaning of. And the particular word in 550 is the word transferee. Is my mother a transferee for these purposes? You know, she received something from me. She received this painting, okay? What was this painting? This painting in my hands was something that my creditors could reach because it counted as proceeds, as fruit of this fraudulent conveyance. My creditors could reach it in my hands. I gave it to my mother. My mother is the transferee. She didn't take it she took it in good faith, but she didn't take it for value. She doesn't get any protection as a transferee of stuff that my creditors could reach. And so what I would do is I'd push on the word transferee and how sensibly to interpret it. And the way in which I get some comfort from doing that is everything in the Supreme Court that says, look, presumptively, we're starting with non-bankruptcy law as a baseline. We're not changing non-bankruptcy rules merely by happenstance of bankruptcy. It seems exceedingly odd that if the creditors could have reached the painting in my mother's hands outside of bankruptcy, I can file for bankruptcy and say, happy birthday.
But aren't you also suggesting that in interpreting the word transferee, we have to interpret that sort of in light of the general prevailing common law notions of these things?
Yeah, hello, yes.
So this is a nice, I'm sorry to cut you off, Douglas, go ahead.
No, I don't know. This actually is probably something of a segue to what Bruce wants to talk about. But basically, I don't think you can interpret any word in the bankruptcy code without understanding the backdrop against which it's written. And I think you've got one of two choices depending upon, you know, how you'd like to do it. You can either say we have a background in the statute that needs to be filled in, or you can say we're interpreting words of the statute. But I think either way you get to the same, you get to the same place. You know, whether you're interpreting words of the statute or you're using federal common law to fill in the gaps in the statute, you should get in the same place. Another way to put it is to say, is there any reason on God's green earth, if I engage in a deliberate fraudulent conveyance and participate in a deliberate fraudulent conveyance, and I could be zapped and my mother could be zapped under non-bankruptcy law, is there any strong bankruptcy policy that says people who engage in fraudulent conveyances should be able to get away with stuff in bankruptcy they can't get away with outside of bankruptcy?
So that is a nice segue to one of Bruce's topics. So Bruce, tell us how it is that the federal courts are supposed to be creating a federal common law of transferees when this recent Rodriguez decision seems to say the bankruptcy court should take great care before they go down the road of ever creating federal common law in the bankruptcy context.
Well, thank you for the well-phrased question, Ralph. I mean, just in passing, for those of you who look at the materials, I have a long screed in it about why the Generation Resources, the 10th Circuit case, is wrong, and probably could have spent my whole 15 minutes reading that. But the issue now is Rodriguez versus FDIC. And actually, I'm going to talk about Rodriguez versus FDIC. I'm also going to talk about the Roman Catholic Church versus Acevedo Feliciano. Two cases from the Supreme Court this last term that actually originated in bankruptcy, don't necessarily interpret any particular provision of the bankruptcy code, but have been causing bankruptcy professionals conniptions in terms of their implications for what we do on a day-to-day basis. Rodriguez arises out of a bank failure. And you've got, and as everyone knows, banks aren't eligible for Chapter 11, and this was the classic case in which the bank was taken over by the FDIC in receivership, and the bank holding company then filed a Chapter 11. As is also the case in most of these bank group bankruptcies, The losses of the bank that were ultimately realized could be utilized to reduce past tax liability and result in a hefty refund. And then the question arises, who gets the refund? This is all tax law. This isn't bankruptcy law yet. But under tax law, the IRS permits the parties in a corporate or consolidated structure to nominate one of the parties either as agent or as the recipient of the funds, and also the person who will pay. Usually the regulations focus on who's going to pay the tax as opposed to who's going to get a refund, because the IRS never wants to give a refund anyway. So not surprisingly, in the Rodriguez case, there was a big refund. And the problem was that this is an area in which courts outside of bankruptcy had created all sorts of rules, so-called Bob Richards rules. Bob Richards was a car dealership in a consolidated arrangement. And the Bob Richards rule actually initially is probably not problematic. It says when there's a refund to be had, it should go to the entity in the corporate structure that incurred the losses that led to the refund. And that's kind of a background default rule, probably not problematic. But Bob Richards came around, I think, in the 70s and the 80s, and there's been all sorts of interpretations about it from then, because there have been all sorts of bank failures. The FDIC failures and the savings and loan failures in the 90s, bank failures every 10 or so years. And so there was a lot of litigation fighting the FDIC, fighting the trustee of the holding company as to who gets a significant refund. And it made a big difference, because if it went to the FDIC, nobody else but the FDIC got it. If it goes to the trustee, then the bondholders at the holding company level would at least get some recovery. And so what the 10th Circuit, again, 10th Circuit, love them, did with this is they said, okay, here's a whole series of rules about under Bob Richards, and some of them tell us how to interpret contracts. And we're going to interpret this contract according to federal rules. And they do. And the FDIC doesn't like it, takes it up to the Supreme Court. And the Supreme Court looks at this and says, why are we interpreting contracts made under state common law according to a federal common law of bank holding company rules? In essence, they said, there is no presumption of a general federal common law. You haven't really shown us why state law is not adequate to resolve this dispute, because here, this was a case in which they had an agreement. There was a tax allocation agreement between the holding company and between the bank. It was just pretty badly drafted. And you needed interpretive rules from somewhere to figure out how you were going to construe the obligations and how you were going to figure out who got the pot of gold in the form of the refund when it came back. And the Supreme Court said, that's something that typically state law always handles. As they said, and they quote, state law is replete with rules ready-made for such tasks. Rules for interpreting contracts, creating equitable trusts, avoiding unjust enrichment, and much more. So Justice Gorsuch, in drafting this, basically said, we don't know where this is going to come out, but you used the wrong set. You pulled the wrong book off the shelf to interpret this contract. Go back and pull the state law book off the shelf, which in fact the 10th Circuit did on remand, and applied Colorado law and said under Colorado law it goes to the FDIC.
Say, Bruce, I'd just like to comment on this because it seems to me this is the Supreme Court telling the federal courts and the bankruptcy courts to restrict their use of freewheeling equity. And, that's good and it's bad. And, I think that some of the principles that have been established over the years that might be termed federal common law can be replaced by teasing meaning out of some of the relevant statutes. Something like critical vendor law, can't be viewed now as federal common law. It probably should be viewed as something that grows out of 363B. But there are some very important principles that I think have grown out of the federal common law. For instance, you take the concept of recharacterization. Now, I suppose what we could do is we could look at state law and forget federal common law, but how about something like substantive consolidation, where there is no state law equivalent, but we all know that we frequently use substantive consolidation. There doesn't seem to be any provision in the bankruptcy code that we can hang our hat on to justify it. What do you think happens to something like substantive consolidation after this case?
Not much, although, you know, I'd have to think through that a little bit longer. I mean, most substantive consolidation law falls back on state law principles with respect to veil piercing and agency, and invoke those, if you will, creditor remedies to assess the wisdom of honoring the formalism of different entities. Now, we can go back, you know, Justice Douglas was famous for creating, I mean, he did it in Samsel and in other cases in terms of creating remedies based on equity. I've kind of recently written about this as well. I think bankruptcy courts have equitable powers. There's just no doubt about that. I mean, if you take a look at the claims allowance process, they can disallow any claim on any equitable grounds a state court could do it. So there's equity power in the bankruptcy system. And the question is, are you creating a remedy there that, two things. One, that exceeds what you could do under state law? Because I'm not too worried about, I mean, in one sense, Rodriguez was a little bit of a red herring, because you might get the same result under what was federal common law as you would under state common law. I mean, again, it's like the issue of, you know, whose state law do you apply when the UCC is at issue? Doesn't matter, because it's usually the same law everywhere you go. But with respect to substantive consolidation, even if you get to the point where you say, well, you're trying to do something that can't be done under state law, I guess under a receivership or an assignment for the benefit of creditors or something like that. What the court has said before in the Cayman case in Kimball Foods is we do interpret and have federal interpretive rules or federal fashioning of remedies when there's an important federal interest at stake. And I'm less worried about substantive consolidation, and I'm more concerned about what someone will do when they get to something like the word proceeds in 552B, or when someone takes a look at what a purchase money security interest is under the hanging paragraph of 1325A. Those are words that exist in both realms, state common law, and they're in the statute. Do we look to and slavishly adopt the state law interpretation of those words? Or do we say there's an important federal interest here? I mean, again, 552B is a very debtor protective provision. Perhaps there are federal interests that would say, well, we're not going to take a look at state law here as a be all and end all. There are some federal interests here, even more so in purchase money security interests, because the states aren't even uniform on that. I mean, the Article 9 actually took a pass on defining that for consumers. So I think, you and I have had this discussion. I think a yellow flag and not a red flag is appropriate for Rodriguez, in the sense that you need to be a little bit more cautious in terms of where you're getting the law. But, you know, as Douglas has pointed out in Generation Resources, a lot of times there are rules, there are provisions, there are schemes of relief that federal law borrows or incorporates state law. I mean, I think in terms of the proceeds and using principles of restitution for 550, that makes a lot of sense. I mean, in one sense, you're applying federal law because you're interpreting 550, but you're incorporating kind of the state law. We saw that in Butner. I mean, that's the best example here, where the court just said, listen, we don't care about the differences in real estate foreclosure among the states as impacting a federal notion. We think that federal law creates, state law creates property rights. We'll look to state law. But when we're dealing with something like substantive consolidation or recharacterization, and by the way, just a shout out, if you want a good article on that, Wither Recharacterization by my co-author Larry Ponoff is one of the better things written on that out there. What you're doing is you're impacting the federal relief scheme and not necessarily reinterpreting rights, because as you point out, sometimes there's just not a lot that's similar to substantive consolidation under state law. In essence, it develops more in the federal system.
So Bruce, isn't part of the ambiguity that, well, even if we say we're going to follow state law, in some instances when we do that, we're still creating federal law because we're not adopting any particular state's law. For example, when there's differences between the state's law, we're just creating a general federal common law for purposes of this particular provision. And I think substantive consolidation is a good example of that. Yes, there are analogous principles in state law on sort of disregarding entity boundaries for purposes of creditors' access to assets, but there's no precise equivalent unless, you know, receiverships do something like that, less assignments for benefit of creditors do something like that, but I've never seen anything like that where they sort of do this massive piercing with respect to all creditors all at once. It just doesn't exist outside bankruptcy. So even though you say we have to incorporate state law principles, no, we really have to create an analogous principle under federal law to deal with the unique bankruptcy context.
I don't disagree. I mean, but I think you got to start somewhere. I mean,
Right.
we're not starting on a blank slate.
No,
But my point is, there is still a general federal common law. There are times when you
There's
have
a federal law of interpretation, Douglas.
No, I would say I'd start just with the observation. This is just Kimball Foods at some fundamental level, which is there is common law out there, but if you need to access the common law, the default is you simply go to the state law. Now, if there's some particular bankruptcy reason, again, there are bankruptcy issues peculiar to bankruptcy implicated with substantive consolidation. But let me, Ralph, let me give you an example. Let's say we have a preference action. I'm thinking of Mississippi Valley, which is a case Bruce talked about a couple of years ago, where one of the issues is tracing. In other words, money was given back to somebody who was also a creditor. The question is, was it really that creditor's money or was it really the debtor's money? And it was money put into a bank account, and it's a fund, it's put into the bank account, it's taken out of the bank account. And the question is the money that goes to this creditor really the creditor's money, or is it money of the debtor? What the Seventh Circuit did, I think completely sensibly, is it looked to the state tracing rule. Different states have different tracing rules. Illinois, which is the law that governed here, was the lowest intermediate balance test. It applied that, and I think it applied it correctly, because either they were simply applying state law, or I think probably the better interpretation is they were actually applying federal common law. And the source of federal common law, when there's no particular federal bankruptcy policy about tracing, is to look at the law of the forum state. And so I think that's a completely appropriate dance. It doesn't unsettle any bankruptcy principles, and you don't have the Seventh Circuit coming up with its own tracing rule.
Right, and the only distinction is sometimes federal common law adopts state law and says it's a particular state's law that will supply the federal common law rule, the state law rule that would otherwise apply to this particular transaction. But in other contexts, you don't do that. You create a general federal common law that's consistent with the general, existing.
Well, I mean, again, my example of proceeds would be that. I mean, in many large bankruptcies, right, you're going to have a number of different states involved, and and there's the possibility for conflicting decisions if, in fact, those states have differences in the way in which they treat proceeds, and if you have a different approach to 552B.
So this is your proceeds example under 552B?
Yep.
But isn't there an even stronger argument that you just need a flat out federal common law rule there that operates independently of state law, which is almost always the UCC?
I think, well, I mean, we're arguing, I think, about the 10th and 12th angels on the head of a pin here, but
no, I don't think we are. I think because 552B implicates a unique bankruptcy allocation issue that doesn't really exist under state law. And if you say that definition...
Well, actually, it contradicts state law. I mean, 552A contradicts state law.
Right. which to me is the paradigmatic example of when you have to have a federal rule and you can't allow the Article 9 drafters to determine that bankruptcy.
Well, I think the Article 9 people are greedy. I mean, that's always been the case, and Grant Gilmore kind of noted that long ago. But I guess the point is, if Congress is going to contradict state law in 552A and cut off after acquired property clauses, but then bring it back in for proceeds, the question is, where the hell did they get the notion of proceeds? And that then is going to take you either down a rabbit hole, or it's going to take you back to state law to understand what proceeds are. And it's even weirder because the word proceeds was used in 1978, means something different under state law now than it did then.
And the Article 9 definition in some ways departs from the pre-existing common law versions of proceeds.
Absolutely.
Under law. So
Absolutely.
to me, that's a perfect example where for bankruptcy policy reasons, we have to have an independent definition of proceeds in 552B.
Which I think I agree with you on. I'm just saying that the question is, it's a different issue than just saying, okay, we've got 3 states, which one do we pick?
Right.
I think it's like we got 3 states, which one do we start with? And then how much do we carve out? Because
Right.
we've got an overriding federal principle.
Right. You have to start somewhere. I think we agree with that. Okay. We also have to end somewhere. So this is the end of Bruce's discussion. I'm sorry, we're not going to have time to talk about the nunc-pro-tunc issue because we have to keep things moving. We're also going to have sort of a sharp separation between more substantive issues into procedural issues in the latter half of our panel discussion, starting with the Supreme Court's Ritson decision regarding when is an order a final order for purposes of appeal, and then we'll also have some sort of jurisdictional issues that we'll discuss regarding jurisdiction to liquidate a non-dischargeable debt and enter a money judgment. But let's start with and there are some actually interesting synergies between those two topics. But let's start with the finality issue, which the court gave us a decision in the Ritson case following on the 2015 decision of Bullard. The court itself said that Ritson was consistent with Bullard. I'm not sure that's true, but Rick's going to sort of guide us through Ritson and how Ritson enriches our understanding of finality for purposes of appeal in the bankruptcy context. Rick, go ahead. Rick, you're muted, so I think you're going to need to turn your microphone on.
Thanks, Ralph. I don't know how I got muted, but in any event, well, welcome everybody to the twilight zone of bankruptcy appeals. Before I delve into the Ritson case, it would be helpful if I provide a little bit of context. You remember that 28 U.S.C. section 158 provide for 3 types of appeals that can be taken from a bankruptcy court. The first is final judgments, orders, and decrees. The second is interlocutory orders that either enlarge or reduce the period for which the debtor has the exclusive right to file a plan in Chapter 11. And the third is for all other interlocutory orders with leave of the reviewing court. So the looming question over this has always been, what is a final order? What is a final decree? What is a final judgment? And I think it's safe to say that an order that resolves an adversary proceeding is almost always going to be a final order subject to appeal. But what about orders that arise from contested hearings under Rule 9014, or even matters where there's no opposing party, but the judge just denies the relief that's requested by the movant? So how do we figure out when those matters become subject to appeal? Well, this creates 2 practical problems. One is that if we file the appeal too early, the appeal may get dismissed for lack of jurisdiction. And on top of that, we may gum up some of the proceedings at the bankruptcy court below simply because a lot of the bankruptcy judges will take the position that once a matter is up on appeal, they can't touch anything that is related to the matter on appeal. The second problem, and this is the problem that the lawyers in Ritson ran into, is that if you wait too long to file an appeal to the order, you may find that you blew the date for taking an appeal. And the next most important thing is for you to send a notice to your malpractice carrier. So there are these dates that become very, very important in our practice. Now, in 2015, as Ralph suggested, the Supreme Court decided Bullard, and there the court found that denial of confirmation of a Chapter 13 plan was not a final order because, quote, it didn't dispose of a discrete dispute within the larger bankruptcy case. So that was more or less the standard that was developed in Bullard. Now, with this background, the Ritson case comes along. And Ritson involved a situation where Ritson enters into a contract with a debtor to purchase some real estate. The real estate sale never closes, and each of the two parties are now accusing the other of having been the first to breach the contract. The matter goes into litigation brought by Ritson in the state court of Tennessee. And when the case is ready for trial, it's nearing trial, the debtor files a Chapter 11 invoking the automatic stay. Ritson blazes into court asking for the stay to be lifted so that it can then return to the state court and complete the litigation on the real estate contract. The bankruptcy judge denies the motion to lift the automatic stay. And rather than taking an appeal at this point, Ritson decides instead to file a proof of claim and assert its claim against the bankruptcy estate. Now, the bankruptcy judge conducts a hearing on the proof of claim, which has been objected to by the debtor, and decides that the claim should be disallowed in its entirety, and then goes on to confirm a Chapter 11 plan. The Ritson then takes an appeal of two of the orders. First, it takes an appeal of the order disallowing its claim, and second, it takes an appeal of the denial of the request to lift the automatic stay. The matter goes up to the district court. The district court affirms the bankruptcy judge on the disallowance, and then finds that Ritson blew the date for filing an appeal, that it was too late to appeal the order on the stay because the order was final when it was docketed. The Sixth Circuit affirms the district court, and Ritson then goes ahead and seeks further review at the Supreme Court level. Now, Ritson has lost at the bankruptcy court level. Ritson has lost at the district court level. Ritson has lost at the Court of Appeals level, but this obviously doesn't deter it. It now goes up to the Supreme Court, and the Supreme Court rules against it 9-0. And the decision is written by Judge Ginsburg, and she says that the stay order, the denial of the stay lifting, was not like the order in Bullard denying plain confirmation, because the stay order, quote, disposed of a discrete procedural unit within the embracive bankruptcy case. So I think we're going to be hearing from time to time this phrase, discrete procedural unit. The court also rejected Bullard's, the court also rejected Ritson's view that the stay litigation was part of the claims adjudication process. The court says those are two completely different processes. And the court also held that orders granting or denying stay relief are final, period, unless the order is without prejudice, in which event the court does not actually issue a ruling. But the clear implication is that if the court were to enter an order granting relief from the stay or denying relief from the stay without prejudice, that type of an order probably would not be final and appealable. Now, I just want to mention.
Rick, isn't that most orders on relief from stay? I mean, the property value may decline. You can always file again if circumstances change, right?
Well, I think that that's true. I think that, that's why I believe that the effect of this ruling is going to have limited applicability, okay? I think that when you're dealing with moving targets, like adequate protection, like lack of equity, like necessary for an effective reorganization, those kinds of issues that come up in many of the motions to lift the automatic stay, by definition, the orders are going to be, unless the stay relief is granted. If the stay relief is denied, then almost by definition, you've got a moving target, and that there's going to be, if not an explicit without prejudice, there will be sort of an implied without prejudice. But I think that one of the things that's going to end up happening is that judges may become aware of this and may start incorporating the language without prejudice into orders that deny lifting of the automatic stay. So I think you make a good point.
But if you permit implicit without prejudice, doesn't it completely gut the effect of the Supreme Court's decision?
Well, some instances are just going to be so obvious that it's without prejudice because of this moving target concept, that I don't think that it will. I don't think that it will. I mean, I think it depends on the details. It depends on exactly what the issues are before the court. But I do think if you have just a situation where there's a motion to lift the automatic stay and there's a lack of adequate protection, and the judge says, well, right now there's adequate protection, even if the order doesn't incorporate it into it without prejudice, everybody's going to know it's without prejudice, and that the creditor can come back in a month from now if there's any kind of a change in circumstances. So
bankruptcy judges might know that. I'm not so sure about district court judges.
That's right. These arguments are being made to district court judges and court of appeals judges, not bankruptcy court judges.
Well, all the more reason why the practice ought to develop, whether you're a practitioner before the court or whether you're a bankruptcy judge, you might want to make that implicit ruling explicit. Now, there are some other things in the decision that might aid our ability going forward to determine whether something whether an order is final or interlocutory. First of all, the court makes it clear that this ruling on stay relief applies no matter what the grounds for the stay relief are. This is not a situation where it only applies in a situation where the creditor is attempting to go back to a different forum. This would apply to the adequate protection type of motion, or lack of adequate protection type of motion. Second, the court finds that since motions to lift the automatic stay are listed explicitly as core proceedings into 28 U.S.C. 157, that this is a procedural clue that they are discrete proceedings. However, the first item in the list of core proceedings is administration of the or matters concerning administration of the estate. So obviously, core proceeding definition can't be a very reliable method of determining these procedural clues. Third, the court says if the motion to lift the automatic stay has a lot of facts that overlap some other proceeding, that doesn't mean that you're dealing with non-discrete or with discrete or non-discrete proceedings. So the fact that some of the issues that came up in the motion to lift the automatic stay were duplicated in the claims allowance procedure, that has nothing to do with whether or not the motion to lift the automatic stay was final.
So Rick, we've only got a couple minutes. What's our takeaway? So Bullard said that the plan confirmation proceeding for purposes of appeal subsumes a lot of individual contested matters along the way. They said for relief from stay, that contested matter, grant or deny, is an individual appealable proceeding. What about everything else? What's our analytical framework for deciding this in other kinds of cases?
Yeah, here are the takeaways. We know what the automatic stay rule is. Orders are final if they resolve a discrete procedural unit. That's the basic guideline. When in doubt, consider filing an appeal. If it turns out that the order is interlocutory, at least you've protected yourself against what happened in the Ritson case. And if you anticipate needing to take an appeal, maybe the motion that you file could be repackaged as an adversary proceeding, so that if there is a final order or if there is a resolution of that, you have a stronger chance of being able to seek some kind of review on appeal. Any event, I think that that's the takeaway. I think that ultimately Ritson is helpful in the context of the automatic stay. I think it announces a rule. The problem is the implementation of the rule is not clear.
But it's nice to have a clear rule on automatic stay, since that's one of the most litigated things in bankruptcy.
True. So, subject to the problem that you and Bruce raised, which is that a lot of stay motions are going to be granted or going to at least be denied without prejudice.
Right. Okay. Thanks, Rick. So the last topic we want to discuss is a fairly significant jurisdictional issue that's been muddied by a recent Seventh Circuit decision, the In re Bush decision from last fall, which concerns jurisdiction to liquidate and enter a money judgment on a debt that's been declared non-dischargeable, which turns out to pose difficult jurisdictional issues, both with respect to the stern issue of whether a bankruptcy judge has core jurisdiction to liquidate and enter a money judgment on a non-dischargeable debt, but also with respect to the preliminary subject matter jurisdiction issue. Is there any federal bankruptcy jurisdiction at all for even a federal district court judge to enter a final money judgment liquidating a non-dischargeable debt? The stern issue is still largely up in the air, including in the Seventh Circuit, which has expressly acknowledged the issue but has not resolved it post-Stern. Bush, though, dealt with the larger issue of, is there any federal bankruptcy jurisdiction at all? Which, if the answer is no, moots the Stern issue entirely. And there are some very troubling statements in the Bush opinion that might lead one to believe that in the Seventh Circuit, there's rarely going to be any jurisdiction at all to liquidate and enter a money judgment on a debt declared non-dischargeable. Personally, I don't think that's the proper way to read the holding of Bush, but I think that the opinion has unfortunately opened that up to question in the Seventh Circuit. So let me take a step back to quickly provide a little background in the analytical framework. And I should be sharing my screen now. Does everybody see my screen? Okay, well, hopefully it's up there. So a dischargeability action in the bankruptcy court will often have two distinct counts or jurisdictional claims that are being made in that proceeding. Count one, having problems with, oh, there we go. Can you still see my screen? No, I'm having problems, sorry. Let me try it again.
That technology is great when it works.
Yeah, it's great when you know how to work it.
I was making a different point.
Yeah. Okay, let me try it again. Okay. So count one is just a request for declaratory judgment definitively stating that a particular debt is or is not within one of the discharge exceptions in section 523A. Count two, or claim two, then will essentially be a contingent claim. If that debt is declared non-dischargeable, count two will ask the bankruptcy court to determine the dollar amount of the debt, enter a money judgment against the debtor. The creditor can then immediately enforce against the debtor. And the ability of the bankruptcy court to be able to entertain that second claim has a lot of efficiency benefits for both the litigants and the court systems as a whole, because in ruling on the dischargeability, the bankruptcy court will oftentimes have already heard most, if not all, of the evidence that's necessary to also liquidate the debt. So it's usually going to be much more efficient and expeditious for the bankruptcy court to do both of those things, rather than making the creditor file a separate state court action on the debt after it's been declared non-dischargeable by the bankruptcy court. But it turns out that finding or articulating the basis for federal bankruptcy jurisdiction over claim two is not so easy. Right? So, of course, the grant of federal bankruptcy jurisdiction to the federal courts has three components that set forth three alternative jurisdictional nexuses, is what they're called, that can bring a particular claim within federal bankruptcy jurisdiction. So these are the arising under, arising in, and related to jurisdictional bases or nexuses. So first, there is jurisdiction over any claim arising under the bankruptcy code, which is the bankruptcy version of conventional federal question jurisdiction. And that is where jurisdiction over claim one comes from. The dischargeability claim itself is a creature of the federal bankruptcy discharge right and the limitations thereon. So determining whether the discharge applies or not to a particular debt is a claim arising under the bankruptcy code. Claim two, though, to liquidate and enter a money judgment on a non-dischargeable debt, that's a pure, simple, non-bankruptcy claim arising under non-bankruptcy law and not the bankruptcy code. So what about arising in bankruptcy jurisdiction, right, over any claim arising in a bankruptcy case? Well, the test that the courts have uniformly adopted for the existence of arising in jurisdiction is it applies to a claim that by its nature can only arise in the context of a bankruptcy case, and that has no existence outside of bankruptcy. Well, that doesn't apply to claim two in our dischargeability proceeding, because the entire upshot of declaring a debt non-dischargeable is this debt is completely unaffected by the debtor's bankruptcy proceedings and continues to exist intact, the same as if the debtor had never filed bankruptcy. So that leaves related to jurisdiction as the only basis for jurisdiction over claim two. But that's also not going to do the trick, at least using the dominant test for the existence of related to jurisdiction, which is the so-called PACOR test. And the Seventh Circuit has its own formulation of the PACOR test that's clearly cut from the same mold, because both are functional tests that ask whether the outcome of the claim at issue could affect administration of the debtor's bankruptcy estate. PACOR, the Seventh Circuit tests, ask whether the outcome of the claim at issue could affect the amount of property available for distribution or its allocation among creditors. Well, those kinds of effect on the estate tests don't work with respect to claim two. So for example, just think about a dischargeability proceeding in a no asset Chapter 7 case. Will liquidation and entry of a money judgment on a non-dischargeable debt have any effect on estate property available for distribution or its allocation among creditors? No, it won't. There is no estate property, and neither claim one nor claim two is going to generate any estate property. Nonetheless, before the Bush decision, every circuit to address the issue had uniformly held that there is federal bankruptcy jurisdiction over claim two, including the Seventh Circuit in a 1991 case called In re Hallahan, and most recently in 2016 in a case called In re Collazo. Judge Posner held, quote, the entry of a money judgment after finding of non-dischargeability is related to the debtor's bankruptcy case. And the rationale that the courts have used to conclude that there is bankruptcy jurisdiction over Claim 2 pretty clearly is just a straightforward application of conventional principles of supplemental jurisdiction. Claim 2 is related to the debtor's bankruptcy case because Claim 2 is logically and factually related to Claim 1. In the words of the Supreme Court's most famous supplemental jurisdiction decision, United Mine Workers v. Gibbs, both claims, quote, derive from a common nucleus of operative fact. So the federal court's independent jurisdiction over Claim 1 also gives that federal court supplemental jurisdiction over Claim 2 as an incident to hearing Claim 1. Well, then comes the Bush decision in 2019, in which Judge Easterbrook called Collazo an unreasoned drive-by ruling subject to ready re-examination, and then proceeded to use the Seventh Circuit's PAYCOR-like functional effect on the estate test to determine whether there was any federal bankruptcy jurisdiction to liquidate a debt that had been declared non-dischargeable. Well, if PAYCOR and or the Seventh Circuit version of PAYCOR are the controlling test, there's rarely going to be any federal bankruptcy jurisdiction at all to liquidate and enter a money judgment on a non-dischargeable debt. For example, no asset Chapter 7 cases. There will never be this kind of jurisdiction, which would be a very, very bad state of affairs, in my opinion.
Ralph, just a quick question.
Sure.
How much of this depends on whether or not the creditor has filed a proof of claim for Claim 2?
If you're in a PAYCOR world, it may matter a lot, and that's actually what happened in Bush, and I think that's the good news. Bush, I don't think, did overrule Collazo and Hallahan. I'm not sure it could overrule those decisions, and I don't think it should be read as doing so. And here's why. Collazo involved the typical kind of dischargeability case I described earlier, involving Claim 1 and Claim 2 in a dischargeability adversary. And it was a no asset Chapter 7 case, creditor alleged non-dischargeability of a fraud debt. Bush, however, was an atypical case in lots of ways, including the one that Bruce alludes to. Most significantly, it's atypical in the way in which Claim 2 in that case was raised, which was attributable to the fact that there were actually 3 jurisdictional claims at issue in the Bush case. So in the Bush case, Claim 1 regarded the dischargeability of tax debts under Section 523A7, and the debtor's tax penalty debt for 1 year was declared non-dischargeable. But there was also a question as to the amount of the non-dischargeable penalty debt, which turned on whether the debtor's conduct was negligent or fraudulent with respect to the tax return at issue, a much larger penalty if it was fraudulent. So the debtors filed a Section 505 motion to have the bankruptcy court determine the amount they owed for that non-dischargeable tax penalty debt. But there was also a third claim at issue in Bush. Since Bush was an asset case, right, the IRS filed a proof of claim for all taxes and penalties owing, including the penalty that was ultimately declared non-dischargeable. Well, Claim 2 was not made in the adversary proceeding that ultimately declared the debtor's tax penalty debt non-dischargeable, right? And it was not that dischargeability adversary that was on appeal to the Seventh Circuit in the Bush case, right? So the typical supplemental jurisdiction rationale for related to jurisdiction over Claim 2 didn't work in the Bush case, because supplemental jurisdiction only applies to claims that are joined and litigated together in the same suit, and that didn't happen in the Bush case, right? In Bush, Claim 2 was joined and litigated with Claim 3, the IRS's proof of claim against the debtor's bankruptcy estate. And that claims allowance litigation is the quote-unquote proceeding, right, that was on appeal to the Seventh Circuit in the Bush case, which harkens back to Rick's topic on defining the proceeding for purposes of the final order, right? That was the proceeding on appeal, was a claims allowance litigation proceeding in the Bush case. Well, claims allowance litigation is concerned with allocation of property of the estate among creditors. So it makes some sense then that the Seventh Circuit in that proceeding, right, would use its effect on the estate test to try to determine whether the bankruptcy court, right, also had related to jurisdiction to determine the dollar amount of the debtor's personal liability to the IRS, right? So the bottom line, I think, then is when claim 2 is made in the more conventional manner in a dischargeability adversary proceeding, Hallahan and Collazo should still be the operative precedent even in the Seventh Circuit, giving the bankruptcy court in that conventional non-dischargeability adversary proceeding at a minimum related to jurisdiction to liquidate the debt declared non-dischargeable and enter a money judgment. So we're very short of time. In fact, we're completely out of time. There was one question where people wanted to know whether Acevedo killed nunc-pro-tunc retention orders and nunc-pro-tunc lift stay orders. Bruce's materials address that question explicitly. And I think Bruce's answer, and I think is probably going to be the dominant answer in the courts also, is no, it did not kill nunc-pro-tunc retention orders and nunc-pro-tunc lift stay orders. In fact, 362D expressly authorizes annulment of the automatic stay, which the meaning of annulment is a nunc-pro-tunc voiding of the effect of.
Couldn't have said it better myself.
There we go. So thank you very much for your attention, and I will now turn the program over to Rick to announce the next panel. Or to the moderator of the next panel. Is that Dan?
Yeah, I'm here.
Dan, go ahead.
All right, thanks. Yeah, well, all right, we'll just skip Rick. So let me welcome all of you to the panel presentation on the Small Business Reorganization Act of 2019, which appears to have some greater appeal in the middle of a COVID-19 pandemic. We have a distinguished group of panelists. I'm not seeing all of them there yet. We need Judge Foray to start her video there. I see her picture, but she's not yet popping up on my screen. Hopefully she'll get here soon. I could spend all of our allotted hour mentioning their qualifications, but let me just talk about them briefly. Robert Handler is going to wave at us. He's a practitioner who has devoted more than 25 years to insolvency matters, represented debtors, creditors, trustees, S&Es, purchasers, and all kinds of commercial insolvencies. But most importantly, for the purpose of our panel, Bob is one of the original Chapter 5 trustees appointed in the Northern District of Illinois. The absent Judge Catherine Foray is the Chief Bankruptcy Judge for the Western District of Wisconsin. She's been on the bench for the last 7 years. Her credentials include the National Conference of Bankruptcy Judges Board of Governors, President of the TMA, 3 committees of the American Bankruptcy Institute, and the co-chair of the Central States Bankruptcy Seminar Advisory Committee. In her spare time, she sits on the bench, holds hearings, tries cases, and writes brilliant opinions. Finally, we welcome Professor Robert Lawless, the Max L. Rowe Professor of Law at the University of Illinois College of Law, where he served as Associate Dean and specializes in bankruptcy, consumer finance, and business law. Professor Lawless has authored countless articles on bankruptcy, including Subchapter 5, and is a co-author for the most recent edition of Secure Transactions. Professor Lawless, will you kindly provide us a short history of the Small Business Reorganization Act and some of its key features?
Sure. So I'm going to stop the screen share, and I've got some slides here a little bit. This is my one. I've got some graphs and figures and stuff, and I'll share the slides again. But you asked maybe to do a little bit of an overview, right? We all know the Small Business Reorganization Act got signed into law on August 23rd, 2019, with an effective date of February 19th, 2020. It creates this new subchapter 5 we've already referred to, with a more streamlined and easier process for small businesses and small business owners, both the business and the owners are eligible for subchapter 5 if they have less than, as the figure currently stands, $7.5 million in debt, total debts, and we'll talk a little bit about that threshold. I thought the first thing I'd do is just talk a little bit about kind of the history of the small business bankruptcy provisions, and maybe it might be surprising, but I would put kind of the origin of where we're at back in the Chandler Act of 1938, which set up the reorganization structure under the Bankruptcy Act of 1898, right? We had Chapter 10, Roman numeral 10, for corporations, and was a reorganization vehicle for large companies. We had Chapter 11, which was a more flexible procedure to do a composition of unsecured debt, principally aimed at smaller businesses. And then we had a Chapter 12, which allowed non-corporate debtors to reorganize what we today would call single asset real estate cases. And there was a legal arbitrage between the different provisions, different chapters. That was a common complaint. There was complaints about satellite litigation prior to the proceedings really even getting underway. So in the 1978 Bankruptcy Reform Act, what do we get? We get a single Chapter 11, right? We have everything moved into a single chapter. This is viewed as a big innovation. Of course, then complaints are about a one-size-fits-all approach. There were complex procedures that were appropriate for more complex cases, and the complaint was that it was just creating cost in smaller cases. So kind of the next thing that happens, of course, right, we get the unification, we get the pushback. We saw changes in 1994. There was a small step toward a separate proceeding, probably the most immediate predecessor of where we're at today with this election to eliminate a disclosure statement. Many of you will remember that the National Bankruptcy Review Commission, the commission that issued its report in 1997, had extensive small business recommendations, had a whole chapter on small business recommendations. There was an undercurrent of concern in that report that small business Chapter 11s not drag out to the abuse of creditors. And then in 2005, BAP-CIPA picked up on this theme with what I would call almost bizarrely punitive provisions directed at small businesses and imposed greater reporting requirements. There were expanded grounds for dismissal. Deadlines became non-waivable. At least in my opinion, the BAP-CIPA rules never worked for small businesses. And the immediate then forebear to where we're at is, of course, the American Bankruptcy Institute Commission on Chapter 11, which issued a report in 2011, took I would describe a fairly different tack from its predecessor, its 1990s predecessor. Right there we saw, again, a recommendation for a small business chapter. Their threshold was a $10 million debt limit. They had flexible reporting requirements, and at least based on my research, this is the first time I ever saw a serious proposal that we eliminate the absolute priority rule for small businesses. So, I kind of wanted just to talk about this a little bit, right? We get the